Good morning, friends. Normally, if a person is killed, normally the police will take it very seriously. And if three persons, if a triple murder case has taken place, the police will investigate the case thoroughly and try to see that the accused goes to gallows, at least a life sentence to be given. But the failure of the investigating officer to ascertain the mental stability of the accused person involved in a triple murder case led to the acquittal on the appeal stage. In the lower court, the accused, she is a woman, she was convicted for life, but in the appeal it was dismissed. So how it happened, let us now know. So you can read it as the case of Lalitha alias Latha, Lalitha alias Latha versus State of Kerala 2021. Right, the judgment given by two judges bench, Mr. Vineet Chandran and M.R. Anita, Madam M.R. Anita of Kerala High Court on 14/6/2021, setting aside the conviction given by the lower court. The main point is the failure of the IO, that means the investigating officer, did not subject the accused to medical examination to determine her mental stability. Right. Now, let us know what happened. The facts of the case better you understand. So, the facts of the case goes to show that on 5/2/2008, not now, 5/2/2008, at about 5 p.m., the accused, she is a woman, Lalitha, intentionally killed her mother and two children. You know their age, they are just 6 and 8 years old, inside the house by slitting their necks with the knife, and also she also attempted to commit suicide by making a slit to her throat also. But incidentally, the neighbors gathered there, they tapped the doors, even though she did not open. They have broken open the doors and sent her to informed the police. The police arrested and sent her to the hospital, where she was there for about 1 week and she was discharged. Later, she was shown the arrest. But of course, the investigation also disclosed that she was not mentally well, and she was doing whatever she likes. Actually, even the family members also fed up with her attitude. But on the ultimate day, on 5/2/2008, she has killed these people. So therefore, a case in crime number 104/2000 under sections 302 and 309 because 302 is murder, 309 is attempt to commit suicide, was registered against her. Of course, she was arrested. As I told you, on 6th itself she was arrested, but she was in the hospital up to 13/2/2008, and later she was discharged. So after going to the hospital, this is the main story. After going to the hospital, then she got the so-called mental instability. She was hospitalized. She took treatment from jail to she was shifted to hospital on 28/4/2009, and she was there up to 1/7/2009. So she was there in jail for so many years also. Once again, she was admitted on 19/10/2012 and discharged only after 1 month, that is on 10/11/2012. Like that, she was treated for schizophrenia, which is a mental stage. But this was not identified by, or this was not mentioned by the investigating officer in the charge sheet. So when the evidence gets to say that her brother also told that she was having the so-called lucid intervals, and she was taken to some Jai Bharat Mangalam State Health Center or something. She was taken Jai Bharat Mental Health Center, Punalur, where she was given treatment from 8/3/2004 to 23/3/2004. Now, the defense has taken, of course, in the lower court they did not hear the defense. Now, the defense has taken advantage in the high court, and they pleaded the general exception under section 84 of the Indian Penal Code. You know what is section 84. According to section 84, if any act done in a state of unsound mind by the person, it cannot be an offense. So he can be excepted for the offense. Of course, basing on the record. So they have produced all the record regarding the previous treatment, regarding the hospital treatment, regarding the treatment in the hospital while in jail. All these things were produced. Now, the court found fault with the investigating officer. So actually, he has to send the accused person also to the court Of course, he has sent him to the court, to her to the court, only to verify whether there are any injuries on her person or not. That's all. Not regarding the aspect. This aspect has taken as a flaw in the investigation, because investigation should be fair. The goal of the investigation is to find out the truth. So, in order to find out the truth, the investigating officer has to go on all lines, but he has not bothered to send her for medical examination regarding her schizophrenia, which has become fatal for the case, and ultimately the two judges allowed the appeal and held that the conviction given by the lower court, that is life sentence, is waived off. So friends, remember, if any police officer sees this video, please try to ascertain the state. Particularly, even the court found fault with the lower court that in 313 examination also the court did not find. 313 normally she may be telling something because she was not mentally sound. At the time also the court did not observe. Actually, in 313 examination, what is the purpose of 313 examination? The purpose of section 313 examination is to see that whether the accused has got any defense or not. So that was totally, actually that was also totally avoided by the lower court also, of course. But now the court has mainly come on the investigating agency. So the fault on the investigation agency, as pointed out by the court, is that the investigating officer did not apply his mind, or the investigating officer did not send her for medical examination. So had he sent for medical examination, definitely the truth would have come to light, and she would have taken the advantage in the lower court itself. But she has to come all the way after 12 years. She has to come to the High Court, and the High Court had to give this type of judgment. Anyway, good judgment, finding fault on the IO, and please, if any IO sees it, don't commit such mistakes hereafter. Thank you very much.